Good evening, friends, and we welcome Justice V. Kumar, a former judge of Kerala High Court, to share his knowledge, and this time not from Kerala, but from Dubai. His passion to share his knowledge can be appreciated from the fact that though he's with his daughter, but he said that his knowledge-sharing journey would continue. And today's topic is trial of warrant cases by magistrates instituted on a police report. Over to you, sir, and we are always thankful to you.
Thank you, Mr. Vikas. Good evening, friends. I am doing this session from a relocated site at Dubai, where I am staying with my daughter. The topic for today is trial of warrant cases by magistrates instituted on a police report, covered by Part A of Chapter 19, CRPC. The relevant sections for this session are Sections 238, 239, 240, 241, 242, 243, 248, and 250 of the Code of Criminal Procedure, CRPC for short. It has already been seen that warrant cases are those cases relating to offences punishable with imprisonment for more than 2 years. Offences punishable with imprisonment exceeding 2 years and up to 3 years are warrant cases triable by judicial magistrates of the first class. Offences punishable with imprisonment up to 7 years, that is beyond 3 years and up to 7 years, are warrant cases triable by chief judicial magistrates. Then warrant cases, offences punishable with imprisonment exceeding 7 years, above 7 years, are warrant cases triable by courts of session, with which we are not dealing today. Today we are dealing with summons warrant cases triable by magistrates instituted on a police report. As in the case of summons cases, warrant cases also can be instituted on a police report as well as on a complaint. Today we are dealing with warrant cases instituted on a police report and triable by judicial magistrates. The first section we are dealing with is Section 238 CRPC, which enjoins compliance with Section 207 CRPC. So in a warrant trial, as and when the accused appears or is produced before the court, the magistrate shall, without any delay, furnish to the accused, free of cost, a copy of the following documents. 1. The police report, that is the charge sheet. 2. The FIR recorded under Section 154 CRPC. 3. The statements recorded under Section 161(3) CRPC of all persons whom the prosecution proposes to examine as its witnesses, excluding therefrom any part regarded which is sought exclusion by the police, the charging officer. That is covered by Section 173(6) CRPC. Subsection 6 of Section 173 enables the police officer to exclude certain portions which are expedient in the public interest not to disclose. Except those, all other documents filed along with the charge sheet, copies are to be furnished to the accused. Then the other set of documents are confessions. Confessions recorded under Section 164 CRPC and statements recorded under Section 164 Clause 5 CRPC. Then any other document or relevant extract thereof forwarded to the magistrate under Section 173 subsection 5 of CRPC. Under Section 173(5), there are many documents enumerated which the police officer is bound to forward to the magistrate. The accused is entitled to copies of all those records. Then only you can ensure a fair trial as guaranteed under Article 21 of the Constitution of India. Now, proceedings under Sections 238 to 240 CRPC are pre-trial proceedings. An order framing charge is purely an interlocutory order and it does not terminate the proceedings. and the trial goes on until it culminates in acquittal or conviction. Therefore, you can't call it a final order so as to be revisable under section 397 CRPC. This was the view taken by the 4-judge bench decision in VC Shukla versus State through CBI, AIR 1980 Supreme Court 962, corresponding to 1980 Criminal Law Journal 690. Justice Murtaza Fazal Ali, among the 4 judges, is the author of the judgment. But an order discharging the accused is a final order. Why? By discharging the accused, proceedings are put an end to. By discharging the accused, there is a total culmination of the proceedings. Therefore, it is a final order. Unlike in the case of trial of a warrant case instituted on a complaint, in the case of trial of a warrant case instituted on a police report, the prosecution gets an opportunity to lead evidence only after the charge is framed. And in a complaint case, whereas in a complaint case, the complainant gets 2 opportunities to lead evidence. First, under section 244 CRPC, before the charge is framed. And the second is after section 246, that is under section 246 CRPC, after the charge is framed. So there is a pre-charge evidence as well as a post-charge evidence. Pre-charge evidence is under section 244 CRPC. Then post-charge evidence is under section 246 subsection 6 CRPC. So under both, since the pre-charge evidence as well as the post-charge evidence is adduced by the prosecution in the presence of the accused, mind you, the accused has a right to cross-examine the witnesses during both the opportunities, during both the occasions. At the pre-charge evidence also, he has got the right to cross-examine the witnesses, but very seldom this right is being used. But after the charge is framed, the witnesses can be again cross-examined by the accused. That is a substantive right of cross-examination, which is invariably made use of by defense lawyers. This has been beautifully stated by the Supreme Court in Ajay Kumar Ghosh versus State of Jharkhand, AIR 2009 Supreme Court 2282, AIR 2009 Supreme Court 2282, corresponding to 2009 volume 14 SEC 115. Justice V.S. Sirpurkar is the author of the judgment. Now, if 2 charges arise out of the same transaction, one of a summons case, that is below 2 years, and another of a warrant case, that is imprisonment above 2 years, warrant procedure is to be followed, because the graver offense, the trial for the graver offense should be resorted to. This is what the Supreme Court, the Kerala High Court, held in State of Kerala versus E. Bhaskaran Kunyi Kelu, 1970 KLT 650, corresponding to 1971 Criminal Law Journal 955. The author of the judgment is Justice P. Narayana Pillai. Now, if in the same transaction, offense committed by one of the accused is triable as a warrant case, and the offense committed by others is triable as a summons case, then also warrant procedure is to be followed. Mappila Sami Tevar versus Muthuswamy Iyer. Mappila Sami Tevar versus Muthuswamy Iyer. AIR 1949 Madras, page 76, corresponding to 1948 Criminal Law Journal 587. The author of the judgment is Justice Govinda Menon. Now, yet another proposition is, when after cognizance is taken on a complaint, the police files a police report for the same offense and against the same accused, and the magistrate takes cognizance of the offense, he shall try both the cases together as if the cases were instituted on a police report. This is the principle governed by section 210 CRPC. That is, there is a private complaint in respect of an offense. Magistrate is conducting an inquiry or trial in respect of a private complaint. Then the magistrate is made to know that there is a police investigation with regard to the same occurrence, with regard to the same accused and same occurrence, same offense. then the facts constituting the offence should be the same in both cases. In such a case, the magistrate is entitled to club the two cases into, rather consolidate the two cases and conduct a joint trial as enjoined by section 210 CRPC. But supposing the facts constituting the offence in both the cases are different and there are different offences. In one case, all the offences in the other case are there, but there is some additional offences. Accused also, there are more accused in one case. In such case, section 210 cannot be resorted to. They have to be separately tried one after the other and judgment to be pronounced in quick succession. Now we pass on to section 239, when accused shall be discharged. Now the criterion for discharging the accused, after considering the police report and the documents sent along with it and making such examination of the accused, and after giving the prosecution and the accused an opportunity of being heard, is that the magistrate considers the charge against the accused to be groundless. Groundless. This is the guiding principle under section 239 CRP. After considering the entire prosecution records, after hearing the accused, after hearing the prosecution, if the magistrate considers the charge against the accused to be groundless, that is, there is no ground for proceeding against the accused, he shall discharge the accused. That is 239. While giving the prosecution and the accused an opportunity of being heard under section 239 and 240 CRPC, the material which the magistrate should consider is only the police report and the documents sent along with the police report. It is open to the police officer to move the court, to move the magistrate for summoning and production of documents. But it is not open to the accused to produce any document or to invoke section 91 CRPC for causing production of documents on his side. He cannot try to falsify the prosecution record by adducing evidence at that stage. His chance, his opportunity to adduce evidence arises only at the stage of defense. Until then, at the stage of framing charge or at the stage of discharge, accused cannot adduce any evidence. The magistrate is confined only to the police report, charge sheet, and the document produced by the prosecution along with the police report. The right of hearing given is only for evaluating the prosecution records to seek for a discharge, nothing else. This was so held by a three-judge bench in State of Orissa versus Debendranath Pati. State of Orissa versus Debendranath Pati. AIR 2005 Supreme Court 359. Corresponding to 2005 Volume 1 SEC 3568. Three judges. The author of the judgment is Y.K. Sabharwal. In fact, this judgment overruled a two-judge decision in Satish Mehra versus Delhi Administration, 1996, 9 SEC 766 by M.M. Punji and Justice K.T. Thomas. That is, in that decision, the learned judges took the view that hearing the accused cannot be an empty formality. Accused should be able to adduce evidence to contend that the prosecution records are false or cannot be believed. The three-judge bench said no. The limited scope of argument is to show that on the evidence, on the face of the prosecution record itself, those records cannot be believed. That is the scope of limited scope of argument for the accused. He cannot adduce evidence or create record. The record is that of the prosecution. Accused cannot be allowed to create new record on the strength of which he can plead for a discharge. This principle in Debendranath Pati was reiterated by another bench in Bharat Parikh versus CBI, 2008, volume 10 SEC 109. Altamas Kabir is the author of the judgment. Again, it was reiterated in Ajay Kumar Parmar versus State of Rajasthan, 2012, volume 12 SEC 406, corresponding to AIR 2013 is Supreme Court 633. Dr. B.S. Chauhan is the author. Now, the phrase hearing the submissions of the accused, hearing the submissions of the accused, occurring in section 227 CRPC in a session trial, which is also warrant trial, means hearing the accused on the record of the case. On the record of the case as filed by the prosecution and not the document submitted and the document submitted therewith. Nothing more. Not the document, not any documents produced by the accused. He cannot produce any documents. Shivalinga Murthy ME versus CBI. That is CBI Bangalore. AIR 2020 Supreme Court 331, corresponding to 2020 volume 2 SEC 768. The defense of the accused is not to be looked into at that stage when the accused seeks discharge. This was again reiterated by Supreme Court in State of Jammu and Kashmir versus Sudarshan Chakar, AIR 1995 Supreme Court 1954. Dr. A.S. Anand and M.K. Mukherjee. Again, Shivalingamurthy versus CBI Bengaluru, AIR 2020 Supreme Court 331. K.M. Joseph is the author of the judgment in Shivalingamurthy. However, a two-judges bench in Nitya Dharmananda versus alias K. Lenin versus Gopal Sheelam Reddy, Akka Nitya Bhaktananda, 2018, volume 2 SEC 93, corresponding to AIR 2017 Supreme Court 5846, that is Justice A.K. Goyal and Uday U. Lalit, judges. They have held that even though the accused cannot ordinarily invoke section 91 CRPC, that does not debar the court from exercising the power under section 91 CRPC suo moto in the interest of justice. Here I have some reservation about this ruling, because what Devendranath Pati, three-judge bench Devendranath Pati held was the accused cannot adduce evidence, nor can he invoke section 91 CRPC for production of documents on his side to falsify the prosecution record. This was the view taken by the three-judge bench. Now there is a two-judge bench which says that the bar is only against the accused, not against the court. Therefore, court can invoke the power under section 91. In fact, section 91 CRPC is a suo moto power. It is not a power given to any of the parties. It is by exercising the power, suo moto power by a party, the party is rather requesting the court to exercise the suo moto power. When a party invokes section 91, it is the suo moto power of the court which is exercised. Therefore, I don't find any distinction between the two, so as to enable the court to exercise suo moto power under section 91, regardless of an application by the party. So with due respect, I have my own reservation. Of course, let us see how the march of law is going to make. Now, at the stage of framing charge, the trial court is not to evaluate and examine in detail the material produced, placed on record by the prosecution, nor is it open to the court to consider the sufficiency of the materials to establish the offence alleged against the accused. Supposing there are two documents which substantiate the prosecution case, the defense cannot argue that the prosecution should have produced 5 or 6 documents. No. Sufficiency of the material produced by the prosecution cannot be assailed by the accused, or even the court cannot say that the documents produced are not sufficient to establish the alleged offence. At this stage, the court is to examine the materials only with a view to be satisfied that a prima facie case of commission of the offence alleged has been made out against the accused. The beautiful decision by Justice D.P. Mohapatra in State of Delhi versus Gyan Devi. State of Delhi versus Gyan Devi. AR 2001 Supreme Court 40 corresponding to 2008 SEC 239. There's one more, what should I say, offbeat decision. The embargo, it has held that the embargo against the accused producing evidence at the stage of framing charge against the trial court will not be applicable to the High Court in a proceeding under Section 482 CRPC taken from the order of the trial court to consider the material which may be produced on behalf of the accused to arrive at a decision whether charge framed against the accused is maintainable or not. That is, though the accused is debarred from adducing evidence before the trial court at the stage of discharge or framing charge, and the court is also precluded from allowing the accused to adduce evidence to falsify the prosecution case, the Supreme Court held that if a proceedings under 482 inherent power of the High Court is taken against that order, this bar under section 239-240 does not apply to the High Court sitting in 482 jurisdiction, and the High Court can consider very crucial documents which may turn the scales produced by the accused and even discharge the accused. This is what the Supreme Court held in Rukmini Narvekar versus Vijaya Satardekar. Rukmini Narvekar versus Vijaya Satardekar. 2008, volume 14, SEC, page 1. Altamas Kabir and Markandeya Kadji are the judges. Then, upon considering the police report and the documents sent along with it, under section 173 CRPC, the magistrate must give the prosecution and the accused an opportunity of being heard. The magistrate has a duty to consider the entire material referred to in section 239 CRPC. That is Century Spinning and Manufacturing Company Limited, who is the state of Maharashtra. AIR 1972 Supreme Court 545, corresponding to 1972 3 SEC 282. 3 judges. The author of the judgment is Justice I.D. Dua. Again, reading section 239 along with section 240 CRPC, if there is no ground for presuming that the accused has committed an offense, the charge must be considered to be groundless, which is the same thing as saying that there is no ground for framing charge. Now, if the charge is found to be groundless, say ground for discharge, it is also a ground for not framing charge. If the charge is groundless, it is a ground for discharging the accused, and it is also a ground for not framing the charge against the accused. This is what the same decision in paragraph 15 held. Century Spinning and Manufacturing Company Limited was the state of Maharashtra. AIR 1972 Supreme Court 545, corresponding to 1972, volume 3 SEC 282. 3 judges, James Shela, I.D. Dua and S.C. Roy are the judges, I.D. Dua being the author of the judgment. Where a magistrate takes cognizance of an offence without taking note of the bar of limitation under section 468 CRPC, the most appropriate stage for the accused to plead his discharge is at the stage of framing charge. He need not wait till the completion of trial. This was so held by Arun Vyas versus Anita Vyas, AIR 1999 Supreme Court 2071, corresponding to 1999 4 SEC 690. The author of the judgment is S.M. Quadri. S.M. Quadri is the author of the judgment. Now here, by discharging the accused, even though the magistrate is actually finding fault with a pre-cognizance illegality, mind you, the case was taken cognizance of without noticing that the offense was barred by limitation under 468. It was ignoring or overlooking the bar of limitation that the magistrate took cognizance of the offense. This is at an illegality at the pre-cognizance stage. But then the accused, the first opportunity which the accused gets after receiving summons and appearing before the magistrate is at the post-cognizance stage. So after appearance, the first opportunity available to the accused is to say that, look, dear magistrate, you took cognizance illegally, okay, without taking note of the bar of limitation. Therefore, please drop the proceeding. This can be said by the accused. That was the view taken by Justice Kadri in 1999 Supreme Court 2071, where the dispute between the accused, that is the employee, and the complainant employer company regarding the claim of possession of the residential flat in the occupation of the employee was of a civil nature. The Supreme Court held that the magistrate was right in passing an order of discharge, and the High Court went wrong in interfering with the order of the magistrate, because the question as to whether the employee was entitled to retain possession of the quarters even after his termination of service. Is a question of a pure civil, is a question purely of a civil nature, which the civil court is to examine. Therefore, the magistrate was right in discharging the accused, whereas the High Court set aside the order of the magistrate and held that charge ought to be framed. The Supreme Court restored the order of the magistrate, holding that the order of discharge was perfectly legal. Jagdish Chandra Nijavan versus S.K. Saraf, AIR 1999 Supreme Court 217, corresponding to 1999 1 SEC 119. The author of the judgment is Justice G.T. Nanavati. Now, if a police report contains offences, some of which are triable as a warrant case and under Chapter 19 CRPC, and some others are triable as a summons case under Chapter 20 CRPC, the magistrate taking cognizance under Section 190 Clause B CRPC takes cognizance of all the offences covered by the police report. Subsequently, if the magistrate discharges the accused under Section 239 for the offences triable as a warrant case, he can still proceed to try the accused for the offences disclosed by the police report triable as a summons case without any fresh complaint in respect of such offence. That is, the complaint contains two offences. One is triable as a summons case, other is triable as a warrant case. Now, under Section 239, the magistrate discharged the accused with regard to the offence covered by the warrant case. Supreme Court held that, notwithstanding the discharge, the magistrate can continue with the trial of the summons case even without any fresh complaint. This is what the Supreme Court held in Pramada Nath Mukherjee versus State of West Bengal, AIR 1960 Supreme Court 810, AIR 1960 Supreme Court 810, corresponding to 1960 Criminal Law Journal 1165. Justice K.C. Dasgupta is the author of the judgment. You may be remembering this particular judge, Justice Dasgupta. It was his view taken from the Calcutta High Court, which was approved by the Supreme Court in R.R. Chari, 50 Supreme Court, wherein the Supreme Court laid down the contours under which a cognizance of an offence on a private complaint is to be taken. When the magistrate, after applying his mind to the averments in the complaint, or rather, after perusing the averments in the complaint, if the magistrate applies his mind for the purpose of proceeding under Chapter 15 CRPC, starting with Section 200 CRPC, he can legitimately be said to have taken cognizance of the offence. This principle was for the first time laid down from the Calcutta High Court by this great judge, K.C. Dasgupta, whose view was upheld by the Supreme Court in R.R. Chari's case. And a long line of decisions following that ruling. Now here the offences were 323 and 332. 323 is a summons trial case. 332 is a warrant trial case. Here the accused was discharged with respect to 332. The Supreme Court held that he could still be tried for the offence under Section 323 IPC without any further complaint. Now, eternal principle is where an order of discharge by the trial court is illegal, the High Court should exercise its revisional power, even suo motu, not to perpetuate the illegality and miscarriage of justice. Notwithstanding that the revision is barred by limitation, the Supreme Court held that High Court is not bound by the bar of limitation for exercising, suo motu exercising the revisional power under Section 397, reduced Section 401 CR. Municipal Corporation of Delhi versus Girdhari Lal Sapuru, year 1981 Supreme Court 1169, corresponding to 1981 2 SEC 758. The author of the judgment is Justice B.A. Desai. B.A. Desai. Now we pass on to Section 240. That is the provision for framing charge. Now the criterion for framing charge against the accused, after considering the police report and the documents sent along with it, and after making such examination of the accused, and after giving the prosecution and the accused an opportunity of being heard, is the opinion of the magistrate about the existence of the ground for presuming that the accused has committed an offence triable under Chapter 19. That is, if the magistrate is of the opinion that the accused has, it's an opinion that there's a ground for presuming that the accused has committed an offence triable under Chapter 19 CRPC, then it's a fit case for framing charge. That is the criterion laid down under Section 240 CRPC. The rules for framing charge by the court are contained in Chapter 17 CRPC, comprising of Section 211 to Section 224 CRPC. Now, this Chapter 17 contains two parts, Part A and Part B. Part A, consisting of Sections 211 to 217, deals with the form of charges. The form of charges. Part B of Chapter 17, consisting of Sections 218 to 224, deals with jointer of charges. Now, you may notice that the main rule under Section 218, subsection 1 CRPC is that for every distinct offence, there should be a separate charge, and for every such charge, there should be a separate trial. For every distinct offence, there should be a separate charge, and every charge shall be tried separately. This is the main rule under Section 218, subsection 1. There are 4 exceptions to that rule. They are contained in Sections 219, 220, 221, and 223 CRPC. They are the exceptions to the rule, whereby under these exceptions, joint trial of more than one offence can be had in disregarding the main rule under Section 218(1) CRPC. Once a charge is framed in a warrant case, instituted either on a complaint or on a police report, the magistrate has no power under the code to go back to the pre-charge stage and discharge the accused. Thereafter, the magistrate can either acquit or convict the accused unless he decides to proceed under Section 325 or 360 CRPC. This is beautifully stated by Justice R.S. Sarkaria in the famous celebrated ruling Redilal Banji Mitani versus State of Maharashtra, AIR 1979 Supreme Court 94, corresponding to 1979, Volume 2 SEC 179. 3 judges. The author is Justice R.S. Sarkaria. That is, once charge has been framed, the case has to go for trial. And the trial, after the long drawn out process, the trial should end in conviction or acquittal. There is no via media in between. the magistrate cannot go retrace his steps backward to the pre-charge stage and discharge the accused. After framing charge, there is no question of discharging the accused by going back to the pre-charge stage. This is what the Supreme Court held in Ritilal Banji. Of course, this verdict was rendered under the corresponding section of the 1898 Code. They apply with full force under the 1973 Code also. Even where the police report is to the effect that investigation has not made out any offence against the accused, it is not mandatory for the magistrate to always accept the police report. Magistrate is not bound by the conclusions reached by the police officer in the charge sheet, in the refer report or charge sheet. But it is not mandatory for the magistrate to always accept the police report. In an appropriate case, after independent examination and application of mind, the magistrate can take cognizance of the offence revealed by the prosecution record and frame charge against the accused, even though the stand taken by the investigating officer in the police report is that no offence has been made out. His view is not binding on the magistrate. Magistrate can independently examine the police report and the documents produced along with the police report, and if he is satisfied that an offence is made out, is of the view that an offence is made out, notwithstanding the conclusion reached by the investigating officer, the magistrate can take cognizance of offence. That is the power of the magistrate under the CRPC. You may refer to State of Orissa versus Habibullah Khan, 2003, Volume 12, SEC 129, Y.K. Sabharwal and B.N. Agrawal. Y.K. Sabharwal and B.N. Agrawal. Of course, there are other rulings of the Supreme Court also to the effect that magistrate is not bound by the conclusions reached by the investigating officer. In a case where the investigating officer says that an offence is made out, the magistrate can independently examine the record and discharge the accused. Likewise, conversely, the investigating officer is of the view that no offence is made out. Magistrate can examine the record, scrutinize the record, and come to the conclusion that an offence is made out and can take cognizance of the offence. Framing of charge in the absence of the accused who had obtained anticipatory bail was held illegal and would defeat the very purpose of Section 240, subsection 2 CRPC. This is what the Supreme Court held in HDFC Bank Limited versus J.J. Manan, 2010, 1 SEC 69679. 2010, Volume 1 SEC 679, Altamas Kabir and Deepak Verma. Now, see, before framing charge, the court has to frame the charge and explain the charge to the accused in the language known to the accused. Charge has to be explained to the accused in the language known to the accused. Then his plea is to be taken. All these formalities have been bypassed by the court by framing the charge in the absence of the accused. His plea is to be taken. Supposing he pleads guilty, magistrate should consider whether the plea is voluntarily made or whether there has been some extraneous influence or pressure on the accused. And even if he pleads not guilty, his plea has to be taken. And presence of the accused is inevitable before the magistrate. So without the presence of the accused, the magistrate framed a charge. It was held that it was illegal, null and void. HDFC Bank Limited, J.J. Manan, 2010, 1 SEC 679, Altamas Kabir, Deepak Verma. Now we proceed to Section 241, CRPC. Conviction on the plea of guilt without a trial. The plea of guilt must be recorded in the words of the accused himself. If the accused pleads guilty, his plea should be recorded by the magistrate in his own words. I always have been using the expression ipsissima verba. The words of the accused, in the very words of the accused. Ipsissima verba is the Latin expression which says in his own words. So the plea of the accused, the plea of guilt made by the accused should be expressed in his own words. And if he is convicted without recording his plea in the words of the accused, then the conviction will be bad. State versus Banshi Singh, State versus Banshi Singh, AIR 1960 Madhya Pradesh 105, corresponding to 1960 Criminal Law Journal, 1960 Criminal Law Journal 482, Shiva Dayal Srivastava. Here, to the charge that the accused had by rash and negligent driving caused the death of a person. When the charge was so framed, his answer was, I have committed a sin. I have committed a sin. This was my first offense. Kindly pardon me. The question was whether this amount to pleading guilty. Court held that this cannot amount to pleading guilty, and the case was the conviction was set aside. The case was remitted back to the magistrate for disposal afresh. So it has to be recorded in the very word, and the plea of guilt should be unambiguous. The plea of guilt should be unambiguous, without giving any room for doubt. And it should be clearly pleaded that, yes, I committed this offense. I am guilty of the offense. I know the consequence. In fact, before recording the plea of guilt, magistrate is to warn the accused about the consequences. You see, Mr. Accused, you are not bound to plead guilty. Even if you plead guilty, the sentence prescribed for the offense is death, imprisonment and fine. I may have to sentence you for imprisonment and fine. Therefore, you are not bound to plead guilty. If somebody has advised you to plead guilty, you are thoroughly mistaken. Don't plead guilty. But in spite of that, if he says, no, I committed this offense, I have the plea, my conscience pricks me. It is because of the prick of conscience that I am pleading guilty. Because one aspect to be noted is an admitted fact need not be proved. Therefore, if the accused himself admits that he committed the offense, the court need not call upon the prosecution to prove the guilt. Therefore, that is the principle underlying this section. Therefore, but the plea of guilt should be unmistakable and unequivocal. Then only the magistrate can act on that plea. Therefore, here he said, I have not committed any sin. That is not pleading guilty. That is why the court set aside the conviction and remanded the case to the magistrate for fresh disposal. Where the personal attendance of the accused was dispensed with under section 205 CRPC, the plea of guilt or not guilty can be made by the counsel on behalf of the accused, if specifically authorized. Now, there are cases where the accused may seek exemption from personal appearance before the magistrate, either by invoking either section 205 at the beginning or under section 317, clause 1 CRPC during the trial of the case. And if the court exempts him from appearing before the court during trial, then or even before recording the plea of guilt, then the accused should authorize his counsel to make the plea on his behalf. And if so authorized, the accused need not be present in court. His counsel can plead guilty. This is what the Kerala High Court held in Noor Jahan versus Moideen, 2000, volume 2, KLT 756. That is corresponding to 2000 Criminal Law Journal 4264. Justice R. Rajendra Babu is the author of the judgment. Now we go to section 242 CRPC. Now supposing the accused, now you might have noticed that under section 241, even if the accused pleads guilty and even if the magistrate is satisfied that the plea of guilt is voluntarily made, the magistrate need not straightaway convict him. The magistrate can still say that prosecution should prove the case. There's a discretionary power of the magistrate to convict him. That is why section says the magistrate may in his discretion, convict the accused. Therefore, if the magistrate does not convict accused on his pleading guilty, then if the accused does not plead guilty, or if the accused claims to be tried, I don't plead guilty, I have not committed this offense, I claim to be tried. In all those cases, the magistrate should post the case for prosecution evidence. That is section 242. The fixing of a date for prosecution evidence is under the following circumstances. 1. If the accused refuses to plead guilty, he doesn't plead guilty, I don't plead guilty, then case has to be posted for prosecution. 2. If the accused does not plead guilty, earlier one is refusing to plead guilty, here he does not plead guilty. 3. He claims to be tried, I should be tried, I am not pleading guilty, I should be tried, claims to be tried, or he was not convicted under section 241 even after he is pleading guilty. Even though he pleaded guilty, the magistrate was having a hunch that he is slightly confused. Actually, he might not have committed this offense because the necessary mens rea could be absent. Therefore, magistrate calls upon the prosecution to plead guilty. Therefore, to prove the evidence. Therefore, in all these 4 contingencies, the magistrate will be justified in posting the case for prosecution evidence. It is not necessary for the prosecution to produce. Now, when the case is posted for prosecution evidence, it is not necessary for the prosecution to produce all the witnesses who had joined in chasing the accused after he had attacked the victim. Supposing after he attacked the victim, the witnesses, the prosecution, 4 of the prosecution witnesses chased him. It is not necessary for the prosecution to examine all the 4 witnesses. It is enough if the prosecution examines 1 or 2 witnesses. There is a wide discretion with the public prosecutor in the choice of witnesses. You may refer to Shyam Behari versus State of UP, AIR 1976, Supreme Court, page 400, corresponding to 1976 to SEC, page 206. The judges are P.N. Bhagwati and R.S. Sarkaria. R.S. Sarkaria being the author of the judgment. Likewise, it is not necessary for the prosecution to examine all the witnesses who were injured in the offense, injured in the occurrence. Hence, non-examination of a witness who was also injured in the occurrence would not be fatal if the evidence of other eyewitnesses is credible enough to found the prosecution case. Supposing there were 3 injured witnesses, the prosecution examined 2 of them. It is not open to the defense to argue that there is a 3rd person who was also injured. Prosecutor has not examined him. Therefore, the case should be thrown out. No. Prosecution has examined 2 of the injured witnesses. That will be sufficient. After all, evidence is to be weighed and not counted. Evidence is to be weighed and not counted. State of UP versus Hakim Singh, AR 1980 Supreme Court 184, AR 1980 Supreme Court 184, corresponding to 1983 SEC, page 55. S. Murtaza Fazal Ali is the author of the judgment. Again, it is the bounden duty of the prosecution to examine a material witness, particularly when no allegation has been made that if produced, he would not speak the truth. Now, there is a material witness for the prosecution. And there is no allegation against him that he has been won over by the accused. And there is no allegation that if he is produced, he will not speak the truth. He will speak the truth. But he has been kept away from the witness box by the prosecution. That would be a case where an adverse inference could be drawn by the court against the non-production of a material witness in view of illustration G to section 114 of the Evidence Act. But the circumstance of is being withheld from the court also cause a serious reflection on the fairness of trial. Apart from the fact that prosecution has withheld, has kept away a vital witness, an important witness from the witness box, it also affects the fairness of trial. You can't say that there is a fair trial. Therefore, for that reason also, the court would be justified in drawing an adverse inference against the prosecution. This was so held in Habib Muhammad versus State of Hyderabad, AR 1954 Supreme Court, page 51, corresponding to 1954 Criminal Law Journal 338, three-judge bench, where MC Mahajan is the author of the judgment. Now the prosecution evidence is complete. Prosecution has examined all the witnesses and marked the document. So when the prosecution has come to a close, evidence of the prosecution has come to a close, Section 313 examination has to be made. Now, the accused has to be examined under Section 313 for the purpose of enabling the accused to explain any incriminating circumstance appearing against him in the evidence for the prosecution. This is an extension of the odi alteram partem, which means that no person shall be condemned unheard. Now, the prosecution adduced evidence, both documentary and oral, and there are incriminating circumstances against the accused, pointing a finger, accusing finger at the accused. In such cases, all those incriminating circumstances should be put to the accused one after the other, and his opinion or his explanation should be sought. He may have lot of explanation, justification to be offered. Therefore, without giving the accused an opportunity to explain the incriminating circumstance, if the court convicts the accused, making use of all those incriminating circumstances, it will be a bad trial. Fair trial, the principle of fair trial enunciated or engrafted in Article 21 of the Constitution of India would be nakedly violated. Now, each and every incriminating circumstance should be put to the accused, and his explanation should be offered, shall be taken. Supposing a particular important incriminating circumstance was not put to the accused during 313 examination, and the court convicted him making use of this particular circumstance also, that conviction will be bad. Courts have gone to that extent. We refer to the Sharad Birdichand Sharda versus State of Maharashtra, AIR 1984 Supreme Court, 1622, corresponding to 1984 4 SEC 116, three judges, Murtaza Fazal Ali, A. Varadarajan, and Sabyasachi Mukherjee are the judges. Likewise, while framing questions under Section 313 CRPC, it is not permissible for the court to put complicated and involved questions in the form of a compound sentence in which several incriminating circumstances have been rolled into one. There cannot be a compound sentence put to the accused incorporating several incriminating circumstances rolled into one. He cannot effectively answer those questions. It was held that 313 examination should be a meaningful examination, and each circumstance should be separately put to the accused. So that it is a view taken by this humble self from the Kerala High Court in Abu versus State of Kerala, 2010, Criminal Law Journal 2324. 2010, Criminal Law Journal 2324. Now, no oath is to be administered to the accused when he is examined under Section 313 CRPC. It is specifically mentioned in Section 313, subsection 2 CRPC. He has no oath is to be examined. Therefore, his examination is not as a witness, for which he can independently come forward as a witness and examine himself, where he'll have to be administered oath. But here, he is examined under Section 313 only for eliciting his explanation with regard to the incriminating circumstances appearing against him in the evidence for the prosecution. He is not examined as a witness. Therefore, no oath is to be administered to the accused. The accused cannot be punished for refusing to answer or for giving false answers also. That is also separately made mention of in section 313, subsection 3, CRPC. Now, the answers given by the accused may be taken into consideration, for or against it. This is what subsection 4 of section 313 CRPC says. It is not to be relied on, can be taken into consideration under section for or against the accused. Even though the unsworn statement of the accused under section 313 CRPC can be taken into consideration in an inquiry or trial, it is not strictly evidence in the case. The accused can give evidence in the case on his own behalf under section 315 CRPC, and you can't treat him as a witness while he is examined under section 313 CRPC. He can voluntarily come forward as a witness, in which case oath will have to be administered administered to him, and his evidence can be relied on also, unlike 313 examination. This is what the Supreme Court, speaking through Justice Hidayatullah, held in State of Maharashtra versus Dr. R.B. Chowdhury, AIR 1968 Supreme Court 110, AIR 1968 Supreme Court 110, corresponding to 1968 Criminal Law Journal 95. Now we come to section 243(1), the scope of section 243 subsection 1, defense evidence. Now, unlike in the trial of a summons case, in a warrant case, trial of the accused in a warrant trial, the accused has a right to be called upon to enter on his defense. In a summons trial, in a trial of a summons case, accused has no right to be called upon to enter on his defense. He will have to voluntarily come forward and say that I got defense evidence. But here that is not the position. After the close of the prosecution evidence and after 313 examination of the accused, the court has to specifically ask him, specifically call upon him to adduce defense evidence in a warrant trial. This is a very valuable right given to the accused. And accused, in case the accused puts in any written statement, the magistrate shall incorporate the same also with the record. Adducing evidence in support of the defense is a valuable right to the accused. Denial of that right means denial of fair trial. Denial of fair trial. Fair trial within the contours of Article 21 of the Constitution of India includes fair and proper opportunities being allowed by law to prove the innocence of the accused. The accused is denied an opportunity to prove his innocence by adducing defense evidence. It is a flagrant violation of the principle of fair trial, even vitiating the trial. You may refer to Kalyani Bhaskar versus M.S. Samburnam. Kalyani Bhaskar versus M.S. Samburnam, 2007, Volume 2 SEC 258, corresponding to 2007, 1 SEC Criminal 577. The judges are G.P. Mathur and L.S. Panta. Justice L.S. Panta being the author of the judgment. Yet another principle is the right of the accused to defend himself is part of human rights as well as fundamental right as enshrined in Article 21 of the Constitution of India. This is what Justice S.B. Sinha held in T. Nagappa versus Y.R. Muralidhar. T. Nagappa versus Y.R. Muralidhar, AIR 2008 Supreme Court 2010, corresponding to 2008 5 SEC 633. Justice S.B. Sinha and Yogeshwar Singh Panta. Justice S.B. Sinha being the author of the judgment. Then, under section 243(1) CRPC, as modified by section 22 of the Prevention of Corruption Act, 1988, the accused has no right to examine any number of witnesses. The object is to ensure, the object of Section 22 of the Prevention of Corruption Act 1988 is to ensure speedy trial of cases. If the court, after perusing the list of witnesses submitted by the accused, considers that the list is intended to delay the proceedings, the court can reject even the entire list of witnesses. The special judge, after all, the trial of a corruption case under the Prevention of Corruption Act is by a special judge. The special judge, if so satisfied, can permit the accused to examine additional witnesses by exercising the power under Section 311 CRPC. Here, in this particular case, a list of 267 defense witnesses was submitted by the accused as the defense evidence. It is not permitted by and the Supreme Court said, no, it will result only in vexation and delay. Arivalagan, Arivalagan versus State. Arivalagan versus State, AAR 2000 Supreme Court 1198, corresponding to 2000 Volume 3 SEC 328. The judges are Justice K.T. Thomas and M.B. Shah. Justice K.T. Thomas being the author of the case. Now we pass on to Section 243, subsection 2. When the accused applies for steps to adduce defense evidence, he should be given an opportunity to adduce defense evidence. While exercising the discretionary jurisdiction of the trial judge by refusing to summon the defense witnesses on the ground that it was made for the purpose of vexation or delay or for defeating the ends of justice, the trial judge is required to record his reasons in writing. Then only the High Court, while exercising its original jurisdiction under Section 397, relative to Section 401 CRPC, will be able to evaluate the reasons given by the trial judge and state its own reasons for disagreeing with the trial judge. See, when the trial judge refuses to issue summons to the witnesses, to the list of witnesses given by the accused, the trial judge has to give reasons why he is refusing to issue summons to the entire list of defense witnesses. Otherwise, the High Court sitting in revisional jurisdiction under 397 right is 401 CRPC will not be able to evaluate the reasons which prompted the trial judge as to why the accused was denied defense evidence. That is what the Supreme Court highlighted in this decision. CBI versus Tunke Alankur, 2013, 9 SEC 611. Volume 9 SEC 611. SB Sinha and Markandeya Kadju are the judges. The expression any witness in Section 243, subsection 2 CRPC does not include the complainant. Hence, the magistrate cannot give direction to issue summons to the complainant to be examined as a defense witness. Accused cannot cite the complainant as a defense witness, opposite side as a defense witness. C.K. Kamaruddin versus Shaukat Ali, 2001, 3 KLT 476, written by the Kerala High Court, corresponding to 2002 Criminal Law Journal, 1289. Justice N. Krishnan Nair. There's one more decision. Thomas versus Vijay Kumari, 2002 Criminal Law Journal, 3108. Justice G. Shashidharan of the Kerala High Court. Both these decisions, it was held that the complainant cannot be summoned by the accused as his defense witness. Then, conviction without giving opportunity to the defense to lead whatever relevant evidence it wanted to produce cannot be sustained. See, the right of the accused to adduce defense evidence is a very valuable right. If he has been denied that right, it will even vitiate the trial. Conviction was held to be unsustainable in that decision. Ronald Wood Mathams versus State of West Bengal, AIR 1954 Supreme Court 455, corresponding to 1954 Criminal Law Journal 1161, Constitutional Bench. 1954 Criminal Law Journal 1161, 5 judges. Justice T.L. Venkatramayar is the author of the Constitutional Bench. Now we come to section 248(1) CRP, acquittal on merits. Earlier we found discharge. We found discharge on merits but without adducing evidence before the evidence is adduced. Now comes the acquittal on merit. That is after the prosecution evidence is over and after defense evidence is also over. If the charge is framed under section 246(1) against the accused for offences under section 494, 495 PA, accused was acquitted merely on the ground that complainant and her witnesses were not available for cross-examination. Held when the magistrate found that the appellant as well as the witnesses were absent, it was the duty of the learned magistrate to have procured the complainant as well as witnesses, if need be, by coercive process. Make them available to the respondents for cross-examination, and thereafter proceed according to law. It was not open to him to acquit the accused merely on the ground that witnesses already examined by the prosecution were not made available for cross-examination. The order of acquittal being illegal, set aside and retrial ordered by the court, the Madras High Court. That is Vasanthi versus Ramaswamy, 1992, Criminal Law Journal 2442. Padmini Jesudurel is the judge who recorded. That is, there cannot be an acquittal merely for the reason that prosecution witnesses were not examined. Prosecution witnesses were not made available for cross-examination. That is not only the duty of the prosecution but also of the court. Court should ensure that the witnesses for the prosecution who were examined in chief are made available for cross-examination. The court, having failed to ensure the cross-examination of those witnesses, was found fault with by the High Court to hold that the magistrate is also equally responsible for the non-examination of those witnesses, and there could not be an acquittal on that ground. And after the charge has been framed, the only order that can be passed is either conviction or acquittal. That we already noticed. There cannot be a discharge. The court cannot retrace its steps backwards to the pre-charge stage and discharge accused. After charge has been framed, trial starts, and the trial should end either in conviction or acquittal. No via media in between. The magistrate does not have any sort of inherent power to set aside the order framing charge. The remedy of the state was to file an appeal against the impugned order, though styled as a discharge. Still, the High Court, exercising the original power, set aside the order which was glaringly illegal. This is what what was held in State of Kerala versus Sebastian, 1982 KLT 724, corresponding to 1983 Criminal Law Journal 416, 1983 Criminal Law Journal 416, by Justice S.K. Kadar of the Kerala High Court. An order of framing charge after an order of discharge after the framing of charge is illegal. That we already see in Redilal Banji, 1979 Supreme Court, page 94. Once a charge has been found, once the charge has been framed and the accused found not guilty of the offence on merit, an acquittal should follow. Once a charge has been framed and the accused is found not guilty of the offence on merits after evaluation of the oral and documentary evidence, an acquittal should follow under section 248(1) CRPC. Harihar Chakravarti versus State of West Bengal, AR 1954 Supreme Court 266, corresponding to 1954 Criminal Law Journal 724, 3 judges. N.H. Bhagwati is the author of the judgment. The case decided under the corresponding section of the 1898 Code. Again, an order of acquittal passed by the magistrate without ascertaining the presence of witnesses and without any genuine effort made to secure their presence was without jurisdiction and was set aside by the Kerala High Court, speaking through Justice C. Shankaran Nair in M. Narayanan versus Unyambu, 1988, Criminal Law Journal, 1375. 1988, Criminal Law Journal, 1375. Because it is the duty of the magistrate to ensure the presence of witnesses being made available for cross-examination by the defense. If that is not done, the acquittal cannot be sustained. It will be without jurisdiction. Now we pass on to section 248, subsection 2. Finding the accused guilty on merits and passing a sentence on him unless section 325 or 360 CRPC are invoked. Where the magistrate finds the accused guilty on merits, he shall, after hearing the accused on the question of sentence, pass a sentence upon him according to law, unless the magistrate proceeds under section 325 CRPC or under section 360 CRPC. What is section 325 CRPC? Section 325 CRPC refers to the procedure when the magistrate finds that he cannot inflict sufficiently severe punishment in the case and accordingly submits the case to the Chief Judicial Magistrate for recording a conviction and passing a condigned sentence. What is section 360 CRPC? Section 360 CRPC and Probation of Offenders Act 1958 deal with the first offenders who are liable to be either released on probation or let off after admonition. If the magistrate does not proceed under section 325 by submitting the case to the CJM or does not apply the benevolent provisions of the Probation of Offenders Act, then he has to be found guilty and an appropriate sentence is to be imposed. Imposition of sentence without considering its effect on the social order in many cases may be in reality a futile exercise. Very pertinent observation by the Supreme Court, taking through Justice Arvind Prasad. The social impact of the crime, example, where it relates to offences against women, dacoity, kidnapping, misappropriation of public money, treason and other offences involving moral turpitude or moral delinquency, which have great impact on social order and public interest, cannot be lost sight of by courts and per se require exemplary treatment. Any liberal attitude by imposing meager sentences or taking too sympathetic view merely on the ground of lapses of time in respect of such offences will be result-wise counterproductive in the long run and against societal interest, which needs to be cared for and strengthened by a string of deterrents inbuilt in the sentencing system. The court will be failing in its duty if appropriate punishment is not awarded for a crime which has been committed not only against the individual victim but also against the society to which the criminal and the victim belong. The punishment to be awarded for a crime must not be irrelevant, but it should conform to and be consistent with the atrocity and brutality with which the crime has been perpetrated. The enormity of the crime warranting public abhorrence, and it should respond to the society's cry for justice against the criminal. Very pithy observations by the Supreme Court, speaking through Justice Arvind Prasad. State of Madhya Pradesh versus Salim alias Chamaru, AR 2005 Supreme Court 3996, corresponding to 2005 Volume 5 SEC 554. Justice Arvind Prasad and S.H. Kabadia, Arvind Prasad being the author of the judgment. Then 248.3 CRPC, how to frame charge for previous conviction and adduce evidence. So supposing there is a previous conviction to the discredit of the accused, how to frame charge? Can the charge for previous conviction be framed before convicting the accused for the main offense. There are some doubts raised by certain advocates and certain judges. Some were of the view that before convicting the accused for the main offense, the question of previous conviction should not enter the mind of the magistrate, and he shall not frame charge, and the charge shall not include charge for previous conviction. This slight some input has to be made in that. Now, section 243 CRP. The charge under section 211(7), charge for previous conviction is to be framed under section 211, clause 7 of CRPC. For previous conviction can be nothing wrong in clubbing that charge along with the charge for the main offense to be tried. Supposing the accused is to be tried for 326 or 325 or 307. Nothing wrong in clubbing the charge for previous conviction also along with the main charge. But one rider. In fact, if you peruse part 3 of the model form number 32, part 3 of model form number 32 in the second schedule to the CRPC, you will find that the charge for previous conviction also can be clubbed in the charge for the main offense. But until the accused found guilty of the main offense to be tried, the charge for previous conviction framed under section 211(7) shall not be read over to the accused, nor shall his plea be taken. His plea on the charge shall not be taken. It can be included in the charge framed, but it should not be read over to the accused, nor his plea to be taken until he is convicted for the main offense. Then, similarly, the previous conviction shall not be referred to by the prosecution or in any evidence adduced by the prosecution unless and until the accused is convicted of the main offense. This is the requirement of section 248, subsection 3, read along with its proviso. 248(3), subsection 3 and its proviso. So, nothing wrong in clubbing the charge for previous conviction along with the main charge, along the charge for main offense. But that charge should not be, charge for previous conviction should not be read over to the accused, and his plea also shall not be taken unless and until the accused is convicted of the main offense. Now, lastly, we come to section 250 CRP, compensation for accusation without reasonable cause. The condition for application of this section are: the case must be instituted upon a complaint under section 2D CRPC or upon information given to a police officer or to a magistrate. Either it should be a private complaint or information given to a police officer or to a magistrate about the commission of an offense. The case must be triable by a magistrate. Second requirement. Third requirement is the magistrate must be satisfied that there was no reasonable ground for making the accusation against the accused. Fourth requirement is action must be taken simultaneously with the discharge or acquittal of the accused by calling upon the complainant forthwith to show cause why compensation should not be ordered. It cannot be taken at a later period. It should be simultaneous along with the acquittal or discharge. Fifth requirement is before compensation is granted, sufficient time should be allowed to show cause, and the acquittal or discharge order must show on the face of it that there was no reasonable ground for making the accusation against all or any of the accused. The order itself should show on the face of it that there was no reasonable ground for making the accusation against the accused. Then the magistrate should not be slow to make use of this section in appropriate cases to stop not only the abuse of their own processes, but also harassment of innocent people. This was the view taken by the Bombay High Court in Emperor versus Jehangir M. Jasawala, AIR 1943 Bombay, page 6, corresponding to 1947, 48 Criminal Law Journal, 929. Leonard Stone, 80 is the Chief Justice was the author of the judgment. The section which applies to both summons and warrant cases is to be applied in a summary manner. The complainant cannot be asked to compensate the accused in a case where the police by mistake prosecuted a wrong person. Supposing the complainant prosecuted the correct person, but the police by mistake prosecuted a wrong person, complainant cannot be made liable under section 2 of the CRP. That is the Om Prakash versus State of Rajasthan, 1975 Criminal Law Journal, 196, P.P. Berry, Chief Justice. This is Rajasthan High Court judgment. This section applies in the case of an offence punishable under the Indian Penal Code or any other law and triable by a magistrate, as shown in column 6 of the first schedule to CRPC, read along with section 26, small a, clause 3 CRPC. So, YD Narayan Hazam versus Ramdari Singh, year 1954, Patna, 145, corresponding to 1954 Criminal Law Journal 221. Justice Das was the author. This verdict is under the corresponding sections of the 1898 Code. The same magistrate who discharged or acquitted the accused alone can initiate action and pass final orders under this section. The succeeding magistrate cannot continue the proceedings initiated by his predecessor in office. Very vital distinction made by the Supreme Court in Nandakumar Krishna Rao Nagiri versus Gunanath Lakshman Kushalkar versus Maharashtra, State of Maharashtra, 1998 2 SEC 355, 1998 2 SEC 355, M. Punji and K. Venkataswamy, judges. A reasonable and probable cause means an honest belief in the guilt of the accused based upon a full conviction founded upon reasonable grounds of the existence of the state of circumstances which, assuming them to be true, would reasonably lead to any ordinarily prudent and cautious man placed in the position of the accuser to the conclusion that person charged was probably guilty of the crime imputed. So the test laid on in Hicks versus Faulkner, 1881, 8 QBD 167, Hawkins J, which was approved in Herminan versus Smith, 1938 Allahabad, 1938 All England Reports, page 1, House of Lords. 5 judges, Lord Atkin rendered the judgment. The order of acquittal or discharge must show on the face of it that the prosecution of the accused was without reasonable cause. It was held by the Calcutta High Court in Bijoy Krishna Chandra, who is a state of state, year 1958 Calcutta 121, corresponding to 1958 Criminal Law Journal 364. Debabrata Mukherjee, Justice Debabrata Mukherjee was the judge. And with that, we come to the close of the trial of warrant trial of cases triable by a magistrate and instituted on a police report.
So thank you, and I could see there was more vibrancy in your voice. It seems the daughter has given more vitamins in your body, and we have actually cherished. I'm just reminded that once we had the first session when you came back from Dubai, that same spirit is coming forth. So we feel that you should stay blessed in Dubai and keep on sharing your knowledge. Thank you. Namaskar.
Thank you.